Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, and once again I'm happy to bring the law and you. I hope you're doing fine, and you, the viewing and listening audience. Of course, you can stream us on WESN CC as well as our podcast, Strictly Legal with Rondell Donawa. Of course, today you can send in your questions. You can send in your questions if you're watching live on our Facebook pages, because today we are going to speak about the understanding the criminal trial process and exactly answering your questions in terms of evidence, CCTV footage that has been obtained from the police as well as a bystander, and how pre-trial publicity works. Of course, I have none other than Mr. Farid Ali, attorney at law. He's no stranger to the Strictly Legal set, so I would like to bring him on. Farid Ali, good morning.
Good morning, Rondell. It's a pleasure to be here.
How are you?
I'm good. I hope you're doing well too.
Good. Yes. So thank you again for agreeing to come on. Because you explain the law in its very simplest form, and of course this is a program dealing with the layman and explaining the various types of legal principles or legal practices. And today we are going to speak about understanding the criminal trial process. I mean, there are a lot of things persons may not know about how trials are run. Most importantly, sometimes you find that persons also are opposed to, or the citizens are opposed to, why is it that certain offenses persons get bail and all these various scenarios. But of course, can you just break down or describe how the criminal division of the judiciary works? Well,
if we look at the court structure, we have at the most basic level what we call the magistracy. Those are the magistrates' courts that are stationed in the districts in which, each district in which persons live. So you may find citizens, you live very close to a court, you may know, well, the Tunapuna magistrates' courts is here, there. Once a matter is a summary offense, it can be treated right there at the magistrates' court. Normally, an offense has to be tried in the district in which the offense took place. So if there was a robbery in Tunapuna or a robbery in San Fernando, you can't have what we call cross-jurisdictional trending of the matter. The matter must be dealt with in the district in which it occurred. So in looking at the criminal jurisdiction, more serious offenses tend to be dealt with at the High Court, and the less serious at the Magistrates' Court. And that happens at every level. If, however, you get a decision in the High Court that you're not pleased with, you're free to appeal the decision in the same way that a few days ago, in February of this year, the High Court ruled in relation to bail and as it relates to remanded prisoners and murder and capital offenses. The state was not pleased with the decision. They appealed the decision. It went to the Court of Appeal. The Court of Appeal ruled in favor of the bail being awarded for persons in remand for murder, and the matter was appealed at the Privy Council level. So there's a structure in the criminal justice system, and there's a structure as it relates to criminal matters.
Now, of course, in the magistrates' court, a lot of times you hear, as you said, summary offenses. The public may not know what are summary offenses. So just explain what are examples of some summary offenses that are heard in the magistrates' court.
Well, let me refer to the police standing orders. There is what we call a police standing orders. The police standing orders is a guide. It's a guide that trains the mind of a police as how generally he should structure his daily activity in terms of his work. It's not law to say a police must follow the guideline, but it's simply an outline as how things ought to be. Now, within the police standing order 28, it defines the levels of offenses. You have offenses listed as minor crimes, serious crimes, and minor offenses. In terms of the structure of summary offenses, a lot of summary offenses are contained in the minor crimes area, and a lot are contained, the majority are in the minor offenses. So some minor offenses would be like loitering. You see someone 2 o'clock in the morning walking, the police stop and ask you where you're going, you can't give a proper explanation. You may be charged for loitering if you cannot offer a reasonable explanation. You may have things like breaches of the peace. Somebody's in the marketplace, in San Fernando market, San Juan market, they're misbehaving, they're using obscene language. A police comes and cautions them and says, listen, you're in a public space. You ought to conduct yourself in a different way. So you could be charged for breach of the public peace. These are summary offenses. It doesn't require any jury to make a determination. You go to court, the charge is read read to you. You plead guilty or not guilty, depending on the charge. The magistrate asks you whether you're willing to go to trial on this issue or whether you want to concede. You could even plea bargain in that instance. So there are summary offenses, simple offenses, liquor license. You're selling beers in a place, no license. Right? Yes. A lot of people sell beers out of styrofoam containers on a Friday evening. Those are summary offenses because you ought to have a license to sell liquor. You might find persons who are into hunting wild animals and you don't have a license, a hunter's license. That is a summary offense.
And we have seen during the pandemic with the COVID-19 regulations, where failure to wear masks and all these various things. I mean, yes, it's fixed penalty. But of course, if you challenge it, it forms part of the summary offense. And
that is a serious issue. Recently, the Ministry of National Security revealed that they made some $32 million in mass fines. That $1,000 that persons had to pay if they were in breach of the regulation, they amounted as much as $32 million. Sheridan Hill, the communications officer for the TTPS, recently made an announcement. Suddenly, the dialogue is no longer people who breach the regulations, it's people who committed minor offenses. So not wearing masks and breaching the regulation came under that category of a minor offense. What people may not know, and just as an aside, those persons who were found to be in breach of the regulation and had to pay those mass fines, it being a minor offense means that they are now criminally convicted. They carry convictions for breaching the regulations that is going to weigh against their names. It has not been clarified in the public space from the Attorney General's office whether those fines and those breaches of the regulation will be treated in the same level that a traffic ticket offense would carry.
Indeed.
So we may find a lot of persons out there should be checking themselves now in terms of whether I am capable of getting a certificate of good character.
Indeed. And of course, while we are sticking with summary offenses, magistrates obviously determine facts.
Yes.
Right? And based on facts and of course evidence, they can now make a determination.
Yes.
Yes. In terms of their remit when it comes to the sentencing, what sort of guide do they use when they sentence on summary offenses?
Well, we have what we call the Criminal Sentencing Handbook in this country. It was first published in 2006, and then there was an amendment in 2016. That document serves as a guide to magistrates as to what category of offenses carry certain sentences. So, like manners and similar manners, meaning a robbery involving a firearm, causing injury to a person, may carry a jail term of, let's say, closer to 10 years. But in sentencing, a magistrate will not or may not extend the full hand of the law in terms of a heavy sentence if they consider certain peculiarities. For instance, they may look at the youth of an individual and see that he committed a serious offense, yes, but he was 17 years old, or he's 19 years old. In other words, if you send this man to jail, he's going to lose the best years of his life, the roaring years of his life.
So therefore, that is where we deal with mitigating factors.
You look at the mitigating factors. You look at the age of the individual. You look at their history of criminality, whether it's a first offense, a second offense, whether they have a predisposition to commit offenses of a violent nature. So a man may have a conviction for smoking marijuana, but that is not a violent offense. It's not a crime of violence, but robbery may be. So if it is, he comes before the court on a robbery charge, and the court has to sentence him now, and they look at his criminal record and see that he's been convicted for minor offenses, they may extend a lighter sentence. It all depends on aggravating and mitigating circumstances. How serious the crime is one factor. The history and antecedents of the individual they're about to sentence in terms of whether he has a history of criminality. And they perch and trend the sentence based on the individual, not generally based on the crime itself.
Right, and now moving into the High Court jurisdiction. Of course, the players, especially in High Court matters, particularly in criminal jurisdiction, are the judges, and also you have jury, not so, as well as judicial officers, which includes the attorneys representing the prosecution as well as defense. Now tell us, now there are legislation which now provides for where trials can be elected without a jury. Just explain the process in terms of what trials that does have jury and what trials that you can elect not to have jury.
When we have what we call serious criminal offenses such as, and according to the standing order, again, standing order 28, it points out some of the serious offenses will be murder, conspiracy to murder, manslaughter, attempted murder, attempted suicide, shooting and wounding with intent. These are serious offenses. These offenses generally are what we call indictable offenses. Indictable offenses is a big word to reflect that it's serious. And when you have an offense that is indictable or serious, a choice is given to the defendant before the court, the accused before the court, as to whether he would like to be heard before a jury, or if it is he would prefer a judge alone trial. The problem we had during the COVID period is because of the 2-year layoff, and we were having trials of a limited nature, not too many trials. A lot of persons who were sitting in remand opted for judge alone trials. They're telling themselves, if it is we sit here in this jail waiting for us to get out of the pandemic, where we can bring juries and bring persons back into a courtroom, I may be just losing another 2 years of my life.
Now, these judge alone trials are for all indictable offenses or specific? Does it include murder as well?
It includes murders. And a popular one would have been simply the Sean Luke trial recently. That was a judge alone trial. There was no jury to make a determination in that instance. So the choice lies with the individual, whether he's willing to allow a judge to make the decision in relation to his innocence or guilt, and to also make rulings in relation to law. The difference is this: it's simple. When you have a jury of one's peers, the jury makes the determination as to facts. They hear the facts, they hear the witnesses, they make a determination based on the believability and the credibility of the witness they're hearing from. When it is the jury has an opportunity to deliberate, they don't carry the bias that one may perceive a judge may have. They may not carry the bias that a highly educated, tertiary educated person may have. So the person sitting in the jury might be a gardener. It may be simply a plumber. It may be somebody who works as a kind of helper, CSR in a store. So in other words, it's simple people on the ground level who make practical decisions based on fact. So somebody may feel safer having somebody like themselves on their level, their rank and file, make a decision concerning their future rather than put it in the hands of an aristocrat as a judge, somebody who they perceive to be not capable of understanding and relating to them as a person. So the benefit of having jury trials is that the factual issues are dealt with by the jury, whereas the judge, he listens to the law. The jury would sit in and hear what the opening arguments are. They would hear what the witnesses have to say in terms of the witness arguments. They would listen to the submissions before the court, and they may listen to the closing arguments and then make a decision. There are times when the jury will be excluded, when there's a legal issue to be discussed, meaning that the judge has to rule on whether some evidence is admissible or whether some evidence isn't admissible, whether they want the jury to be exposed to this sort of information. In other words, the judge monitors.
He monitors
and regulates what the jury hear, because they may not be able to process the finer points of the law. And you don't want to corrupt their mind in terms of confuse them. So you limit them to factual issues and let them rule on factual issues. And the judge gives some directions. Don't be confused if you hear somebody, if you found that during the trial process, Rondell was lying. There are lies that could be condoned in a courtroom. So there are directions he can give and say sometimes when a man lies, it's not that he's lying to be malicious. He might be lying to protect himself in terms of he doesn't want to be seen to be in Tunapuna or seen to be in a certain place at a certain time. He have a wife, he doesn't want his wife to know where he was. So he lies about issues that don't touch and concern the facts in the matter, that don't touch and concern the innocence or the guilt of the individual. So you can, the judge gave you a direction when you found him to be lying there. He was not lying about an issue that touched and concerned the core issues in the matter. He's lying about something that doesn't touch that. So he tells his jury, don't judge him and say everything comes from his mouth, therefore it's a lie. Yeah. So these are some of the practical directions judges give.
Now there's a concept in law called preliminary inquiries. Right, and could you just explain in terms of why is there a need for a preliminary inquiry, particularly when someone gets arrested for a serious offense? I mean, I do know that the first point or the first place that an arrested person presents themselves is through the magistrate's court.
Yes.
Could you just tell the public why is it that they have to present themselves, or why is it that the first court that they go to is the magistrate's court versus the high court, even if it's an indictable offense?
Every offense that takes place must be heard in the district in which it took place. So there are serious offenses that come before the district court, and the magistrate, he is a creature of statute. There's what we call the Magistrates Court Act in Trinidad and Tobago. That act determines how a magistrate can act and what a magistrate can do. When you are dealing with serious offenses involving murder, the magistrate cannot make a determination as to innocence or guilt because the act doesn't allow for magistrates to make a ruling in relation to innocence or guilt in a murder matter. So some serious offenses has to be dealt with at the high court level. And what they do at the magistrates court level is have a preliminary inquiry. What happens at the preliminary inquiry? The role and function of the magistrate is to listen to the evidence, watch the witness, hear what the witness is saying. The magistrate now will listen to the facts of the case. They will have a first-hand exposure to the different kinds of evidence being presented, whether it's CCTV footage, whether it's DNA, whether it's forensic evidence of some kind. They will also look at whether it's fingerprint evidence, whether it's identification evidence. So in a trial process, what that magistrate is doing is they're looking at all the evidence. And based on the evidence, if they believe that the police factual scenario, the facts derived out of the investigation points to some case that individual may be involved, or some factual scenario that somehow incorporates the individual, meaning that the magistrate is of the view, you know what, I am not here to determine innocence or guilt, but I believe that Rondell, Donawa, or Farid Ali has some involvement on some level in this, and that the police investigation did bear fruit, that he has some information that could assist, and that would have caused the charge to be laid. She may say that the fingerprint evidence is tying him to the offense, though he is saying that the identification was faulty and that the individual who saw him wasn't describing him. He was describing somebody who could be just about anybody else, a generic description. Yes, he's an African male, but there are hundreds of African males out there. But the DNA evidence may be tying it to this particular African male or this particular Indo-Trinidadian. So the magistrate at that point may say, you know, the identification evidence is weak, but the fingerprint is strong. The witnesses may have been shaky in terms of the civilian witnesses, but the formal witnesses in terms of the police officers and the expert witnesses, they were strong. So I think generally, let's send the matter before the High Court, commit him to stand trial. He will be remanded in custody at the nation's prisons, and an indictment will be served on him in this country. It may take as much as 10 years, but the indictment will be served upon him, and he will answer to the High Court and a jury. So the preliminary inquiry is really a pre-trial hearing to determine whether this matter is worthy of going before a judge and a jury, whether it's worthy of going to trial.
But wasn't it? I recall that there were proposed legislation to abolish PIs, or preliminary inquiries. How far has that gotten to?
The last reference that was made in relation to preliminary inquiries is the then Attorney General Faris Alwari in January of 2022 indicated that he would like some feedback from the Law Association and from the criminal bar with regard to their views in terms of the elimination of the preliminary inquiry. And everything fell into abeyance since. Right. We haven't heard anything in terms of what is the development. The idea behind removing the preliminary inquiry is they were developing other ways and means of vetting the evidence. Because basically, the preliminary inquiry was a formal forum in which all the evidence would be vetted.
And these 6 years.
Right. What the Supreme Court did, and what the Chief Justice and they did in terms of introducing other ways of vetting the same evidence is introducing the concept of masters and registrars at the High Court. Yes. So you have masters of the High Court now. They have been inserted into the Supreme Court level. And what they do is rather than you swamp the Magistrates Court with a host of preliminary inquiries, you leave the Magistrates Court to deal with simple minor offenses, what we were terming minor offenses earlier, breaches of the peace, exposing oneself in public, any sort of simple quarrels, simple fights. These things can be dealt with at a very limited level at the Magistrates Court. But with the master, the preliminary inquiry now will be handed over to the master. The master will look at the statements, and the master now will be able to make a determination based on reading the documents, whether we can commit this individual to stand trial or not. So in other words, the preliminary inquiry has been eliminated, or the view is to have it eliminated eventually, yes, in order to free up the movement of matters from the Magistrates Court to the High Court.
All right, Farid, I know there's a lot to discuss, but we have to take a break. You're watching Strictly Legal. We'll be right back. And welcome back. You're watching Strictly Legal with my guest, Fareed Ali. Speaking about understanding the criminal trial process. Now, Fareed, let's touch on evidence. Let's touch on why is evidence, I mean, obviously it's an obvious question, but why is evidence so important in let's deal with the criminal proceedings?
Evidence is a direct byproduct of a police investigation. The reason why the police investigates a complaint is to determine whether there's information out there that they can tie the offense or the alleged offense to a person. If it is your investigation reaps no return, like in Trinidad and Tobago, it is being said, it's in the public space that we have an 18% detection rate. So it means to say that the investigations in this country, the chances of it being tying it back to an individual, it's weak. And that is why with this, the high levels of criminality we may find exist and subsist within our country. Now, the thing with evidence is this. There are different forms of evidence. Evidence is like a puzzle. And at the end of the day, if you have 100 pieces in that puzzle, if it is you only have 3, you could only put 3 together, link 3 together, then it doesn't show the complete panoramic picture that you wish to tell. Now, you may have different forms of evidence. The best evidence against an individual is his confession. So when it is a man is brought into the station and the first thing they say, yes, I stole, yes, I thief, yes, I rape, yes, I kill. The police, their job is easy because the best evidence against a man is his own words.
Yes. But then when they go before trial and then the words change and then they say whether they were coerced or forced.
Then we get into procedure.
Yes.
We get into procedure. So when it is a man confessed at the station, we confess before a police officer. The first thing the police officer does is he takes out his pocket diary if he has one, or he takes out his sheets of paper and he makes a note that at 9:05 p.m. on the 27th of July 2022, I had a conversation with Fareed Ali. He confessed the killing, he confessed the shooting. And they put the details, as much details as I give, and they make a note. Then they ask you, Mr. Ali, you're agreeing that we made a proper representation of what you just said here on paper, and they ask me to sign. Then a senior officer who witnessed that will sign under my signature. So then they use that as evidence that there was a confession. They make an entry in the big diary that you see when you enter the police station, and they make entries in other forms, pocket diary, desk diary. And when the collation of these entries, that speaks to evidence. It's evidence of a confession, and there's a written log of it. You have different forms of evidence. You may have scientific evidence, DNA, when they take swab samples from somebody's spit saliva. And when they take these swab samples, they check for DNA in that. They check under the fingernails of a deceased to see if it is you get skin tissue. Because if the person struggled with the other person, that they may have gotten swabs or scraps of skin from the individual they fought with. And if you could check the DNA extracted out from the saliva of the suspect and it matches the skin tissue under the nail of the deceased, then we have scientific evidence. We may have fingerprint evidence, where a man may say, well, I was never in that house, but his fingerprint is all over the house. Mm-hmm. So how do you explain being inside? You're not Spider-Man. Mm-hmm. So at the end of the day, we look at different forms of evidence. We look at the evidence of an IC witness. There are different forms. You look at, if you say, I saw a man while I was standing by the San Fernando Magistrates Court, exiting the San Fernando High Court, the Supreme Court, you have to say, well, I saw an Indo-Trinidadian, slim-built, clean-shaven, right, around 5'4", and then you proceed to describe. If the description is generic, meaning just all I just said is it fits the description of any number, any 100 men, you may say, well, he has a scar over his right eye, he's missing a front tooth, he has a chip on his front tooth. So you look at the identification evidence also under the lighting conditions. You didn't identify him 2 o'clock in the morning, you identify him under heavy lighting conditions, bright sunlight, 9 o'clock in the morning. You look at the distance that the observation was made, there was nothing obstructing his vision. So identification evidence is very strong. We live in a country where the people who are committing crimes sometimes are your neighbors and your friends. Yeah. So you have what we call a verification exercise, which is a different form of identification where we don't need to formally have 8 persons standing fitting the same description behind a one-way mirror and you go to identify the person who you think looks like the perpetrator. You may say, it's my cousin, I grew up with him, we sleep in the same bed, we eat the same food, and we had the same siblings to interact and fight with. Well, so you have verification evidence.
And let's discuss in terms of video evidence. Now, we have seen in high-profile shootings where police has informed the public or put out a release that they've had official CCTV footage
Yeah.
of acts that were committed, but they cannot release it to the public because it can prejudice the trial. However, or they justify why is it that they would have done what they did. And however, in the contrary, you would see that eyewitnesses will have another piece of evidence. Right. That basically debunks what the police is saying. Now, how do we treat with official CCTV evidence from the police, and whether or not they have the authority, or whether or not their views of not releasing it before trial is valid?
The police are under no obligation, and the Ministry of National Security are under no obligation to release video footage that may compromise the integrity of our investigation process. They have a responsibility, an outlying responsibility, when it is you have CCTV footage or footage gathered from cameras on the street, to keep that secure. The security purposes is this. It's tied to whether, if a matter has to go to trial and we release into the public space video footage of Farid Ali running down the road with a piece of wood in his hand, running down a woman, running down a child, the public perception, having seen the video footage, would be one of, this man is guilty. It may not be he's running the individual down who just robbed him of his items and he's running to make a citizen's arrest. The opinion that is formed is man running down child, man running down woman, piece of wood in his hand, evil man. So that is what we may see, may even touch so far as what we may call pre-trial publicity. Yes. That may adversely affect how persons perceive and consume and interpret and digest what they're seeing. So it's within the ambit of the police to withdraw footage from the full view of the public and allow it to feature in the investigation and allow it to feature in the courtroom. However, CCTV footage is very effective. It's evidence that may be admissible in a courtroom.
And why you say maybe?
It's up to the sitting magistrate or the sitting judge to make a determination as to whether the sanctity of the footage is acceptable. A police officer must come and say, where did he get it from? I got it from a camera situated on the corner of Queen and Henry Street, Port of Spain. The extraction of the material was done in a particular way. We use a clean CD. We use a flash drive that was not corrupted
Obviously,
in any way.
you have to lay the foundation to admit that evidence in the court.
Yes. Mm-hmm. And once it is done in its proper fashion, and we trust that the police would do that, then it may be admissible. But that is the difference with when you have video footage from ad hoc items like mobile phones. When civilians do that with their phones, yes, the sanctity of that footage could be doctored. So that is why it is we may rely less on public cameras and individual phones as opposed to official CCTV footage.
But then we have seen that individual phone footage, camera footages have propelled investigations into criminal activities, particularly with police criminal activities.
Right. And when you have individuals who do who have footage from their own personal security cameras at home and their phones, you can go to the police complaints authority and file a complaint, and they will test the sanctity of that footage and whether it's reliable or it's unreliable. And it's not just the video footage that the police complaints authority may rely on. They may be relying on other statements taken from other individuals who may be willing to offer, by way of a signed statement, what they see, and the marriage of the footage that they gather from random sources plus statements would assist in terms of piloting a matter, piloting an investigation, having a matter rightfully called before the court, and assigning an individual some sort of culpability, if it can be proven.
And so therefore, really and truly, CCTV images, it can't be withheld. There's no obligation of the police to release or claim, obviously, pre-trial publicity, as you said.
Right. Yeah. There is no such thing.
Yeah, there's no such thing.
There is no such thing that you have a right to that footage.
Understood. Farid, we have to wrap up, right? We have to wrap up now. Yes. However, if you want to say anything quickly, and of course, I think we have to come back again to further this discussion.
I think that the public needs to be aware that we live in some reckless times in Trinidad and Tobago. The criminality that we are facing on a day-to-day basis is serious criminality. We have to put trust in the police, we have to put trust in the processes and not take the law into our own hands. And I think we are safe in terms of the work that the judiciary and the magistracy has been doing and the input by way of improved legislation from the Attorney General's office, the marriage law that augurs well for the future.
Yeah. And of course, I mean, this is an educational talk as well, right? So the public can be fully aware as to these processes. So thank you very much for reading.
It's a pleasure to be here. Thank you.
Again, guys, it's a wrap. So you have been watching Strictly Legal on WESN. I am your host, Rondell Donawa. See you next time. I will leave you with a quote: "The best preparation for tomorrow is doing your best today." Have a good day. God bless.